Should I be on that picture or not?
No, that's fine. You can talk.
Okay. Okay. Well, we have our judges panel today, and we're pleased to have Judge Gienap, retired Judge Gienap, and Judge Trandle with us. By way of short introduction, Judge Trandle, I know a little bit about her because I was able to attend a year ago in 2014 a presentation where she and her best friend, retired Magistrate Judge Sean Pulkey, received the Women in Law Attorney of the Year award. And what was so fun about that was both knew the other was getting it, but didn't realize they were a co-recipient until sort of the 11th hour. And so that was a fun presentation to be at. Judge Trandle graduated from Augustana College, now University, and USD Law School. She practiced law in Winter, South Dakota, and then in 1994 was appointed to be a circuit court judge, and she's a judge in the 6th Circuit. Now retired Judge David Gienap was for 10 years a judge in the 3rd Circuit. He grew up in Chester, South Dakota, and attended USD undergraduate for his undergraduate degree, and then graduated from the University of Wyoming for law school. He clerked for the South Dakota Supreme Court and worked with the South Dakota Attorney General's office and was an assistant attorney general. He had a private practice in Madison, South Dakota, until he was appointed to be a 3rd Circuit judge. So we're very pleased to have them with us. And if you could just start out and I guess elaborate a little on my brief introduction and kind of describe your personal journey to becoming a judge. Then I'll have just a few more questions, and then we will open it up to student questions.
There's Steve's.
Okay.
I apologize.
That's okay. That's the life of a judge, I suppose. While you're making your way down here, I'll give a brief introduction about Judge Jensen. He's the presiding 1st Circuit judge, and he grew up in Wakanda, South Dakota, so not far from here. Graduated from USD Law School, served as a South Dakota Supreme Court clerk, and was in private practice, I believe, about 14 years before he was appointed a circuit court judge in 2003. So we're pleased to have you with us, and I've asked if you'll just make a few more remarks about sort of your background and your personal journey to becoming a South Dakota judge.
You've already done this?
No, just
You're
started.
putting me on the hook first, sorry.
No, you can go in whatever order you wish.
I'll start since I was last. I guess that's only fair. Well, I graduated from law school here in '88 and then clerked for a year. I don't know that I necessarily had in my mind I wanted to be a judge from the time I graduated from law school. I knew I wanted to practice law and started practicing in a firm. Did primarily litigation, early on some criminal litigation, and then more civil later on in my practice. There was a lot of things I liked about the practice of law. There were a lot of good things about it, but the opportunity came up, and actually the presiding judge at that time moved the position. It had been Judge Tappy, who had served over in the Platte area for many years, had been the other judge in the 1st Circuit, and just because of the way the caseload worked out, they moved the slot over to Elk Point or Vermilion. And living in Union County and being close to that, I thought, well, if I ever want to be a judge and not have to move, this would be the opportunity to do that. And so I made the application and was successful, and I've been on the bench now for just over 12 years. And there's a lot of really good things about it. There's a lot of opportunity to, where you have a sense of public service and the rest. There are hard days or difficult days that you deal with very difficult people. But I think that, in my mind, one of the keys of being a judge is not allowing yourself to become cynical or getting burned out. I think that the worst thing a judge can do is become cynical about people and about the cases that are in front of you, because if when that happens, you don't want to hear what the lawyers have to say, you don't want to hear what the parties have to say, you just want to be done with the case. And I think that's something that as judges we have to always keep in mind is, do I need a break? Do I need to get away for a week? Do I need to, sort of recharge the batteries? And I just think that's a very important component and a very important part of being able to sit and listen and treat people fairly and with respect. So that's kind of my journey, briefly.
I recall sitting in that area many times, so this is kind of a unique place for me to be sitting today. I graduated from law school here in 1985. I was a law clerk in Watertown for a year for the Third Circuit, and then I wanted to do trial work, and so an opportunity came up in Winter, South Dakota to be a part-time deputy state's attorney and work in a civil practice. And so I applied for that and was hired. I worked with that firm with that attorney in Winter we don't really have firms, we're all too independent, so we have separate law offices primarily. I think the only firms there are married people, so it's an independent place to be. So I worked there 2 years, left the state's attorney's office, worked in a different law office, and the reason really that I applied for a judge is when I was in law school, I worked summers for Dave Gienap because I grew up in Madison where he was practicing law. And he called me one day and said, we've got an opening in Madison, and would you consider applying? And I was 27 years old, and I said, thank you, honored, but I think I'm not quite ready for that. And so I declined, and then Judge Tucker was appointed that position, and he was 29 years old, and I went, well, maybe I need to rethink this. So I applied a couple more times and then was appointed in Winter. So I have been a judge for, it'll be 22 years in March.
You were 16 when you started?
16, yeah. And I was 33, so you can do the math. And, but I just felt that day I'd won the lottery, and I did. I mean, it was an absolute dream job. I think it's, from my perspective, I enjoy trial work. As a lawyer, I prefer to be the one making the decisions, and we're not all wired that way, but for me, that was a better place to be. And I also enjoy being out in the Sixth Circuit, where we do a lot of travel, and so every day is a new day, new experiences. I primarily handle 4 counties in the southern end of the Sixth Circuit, so I'm Gregory, Tripp, Todd, which is the Rosebud Indian Reservation, don't do much work there, but some, and Bennett County, I'm back in Bennett County. And so so that's my journey there. I did have a contested election in 2006 and won that election. Campaigning in 14 counties was a new experience for me. I had done campaigning when I was younger, my name not on the ballot, but it was a good experience really, and so I also have that in my background as far as how I then kept my job. And so, I think as Judge Jensen said, a circuit judge and a magistrate judge, I think that you have to like people, no matter, because you see all kinds, and all different situations when we come into a courtroom. I'm now enjoying, we have several project role practice attorneys in my world, and that is just absolutely wonderful to see them come in to court. They are prepared. They're doing a great job. And so for me to see the younger lawyers come into my world, because otherwise there weren't any. I mean, if we did not have that program, we would not have young lawyers out in the middle of the state, especially in rural South Dakota. So that's been a great program, and they're doing great work. And so that's right now, I think, my most favorable part of my job is seeing them come into court, learning their trade, practicing, and doing very well.
Okay, well, as indicated, I graduated from the University of Wyoming. I did undergrad down here and then graduated from the University of Wyoming in 1967. I primarily went to law school because I had a choice of going two places, either law school or Vietnam during the war and the draft, so I decided to go to law school. But once I got to law school and enjoyed law, when I graduated from law school, I took both the Wyoming and South Dakota bar and was contacted by the South Dakota Supreme Court to clerk for them for a year, which was the first year they ever had a law clerk. And then they only had one at that time for the entire, theoretically we're working for the Chief Justice, but they only had one. And then I went to the Attorney General's office, not the criminal end, but at the highway end, where they're doing condemnation cases for about a year, and then went to the U.S. Attorney's office for about 7 years, and then migrated to Madison and went into private practice, where I did a little of everything, but primarily litigation, and hadn't really given any thought to becoming a judge. When I was in my mid-40s, Governor Jankel called me, and there was an opening in our circuit, and asked me to apply. He said, if you applied and got through the Judicial Qualifications Commission, I'll give you a judgeship. And I basically told Governor Jankel, I think my exact words were, who the hell would want to be a judge? And so I went on and continued practicing law, and then when I got to be 60, there was another opening, and I decided I wanted to be a judge. And I think one of the bigger factors in my mind, which had nothing to do with public service or anything like that, is I was, Madison isn't a hotbed for litigation, so most of the trial work I was doing and depositions were where I was staying in motels, and I was getting sick of staying in motels about 10 nights a month and jumping on airplanes quite a little. So I applied and made it through the Judicial Qualifications Commission. The names went up to the governor, and Governor Jankel was again governor at that time. He called me and said, who in the hell would want to be a judge? He had a pretty good memory. But I thoroughly enjoyed my 10 years that I spent being a judge, and still have a contract where I fill in occasionally since retiring. And I lived in Madison, but my main chambers were in Brookings, and I sort of appreciated that too, not being in my hometown where I had practiced for all those years, because I could come back home and normally go into a grocery store or anybody, and people called me Dave and didn't really think I was a judge, and it was sort of nice not to be like a minister where you have to watch yourself in your hometown. But I did enjoy it, and it's a great service, and it's a satisfying experience. And like Judge Jensen alluded, there are some days you wished people would behave better or could compromise easier, but but overall you've enjoyed it.
Could you describe for us some of your expectations for new young lawyers in the courtroom?
I guess I'll go first since I brought it up first. I think that anytime a lawyer comes into a new courtroom, so whether you're a veteran lawyer who's going into a different circuit, I think you have to do a little homework. I think you need to find out what judge you're in front of, what their preferences are, and we're all different. So you're going to find that we all have different preferences. On the Unified Judicial System website, under Circuit Court Information for Attorneys, we have all filled out a little survey that will at least give you some idea of our expectations. If we do scheduling through the court reporter, the clerk, ourselves, whether we prefer email, or it just gives those kinds of preferences. So it's good to look there, whichever judge you're going to appear in front of, that will give you some idea so that you're comfortable there. I think that for any attorney that comes into our courtroom, if you're a new attorney, go introduce yourself to the clerks in the clerks of court so that they know who you are. Introduce yourself, if you have the opportunity, to the court reporter. And the nicest thing you can do for the court reporter is hand that court reporter your business card. They'll have your name, your address, how you spell it, and they will appreciate that. I think that if you move into a new community, certainly, in my world, you would come and ask to visit with me, because if you can get through security, I have an open door policy. So, not that we have much security out
I was going to
there.
say, you have security.
I have a punch code to get through a door, okay? So you have to, somebody has to get you through that door. But I think you can come and chat, and I think you should. And that gives you also an opportunity as far as expectations. When you come into a courtroom, watch the lawyers that are experienced, that are good, and they will help direct you on your behavior in the courtroom. I know that a lot of new attorneys come in and they talk really fast, and you really can't do that because you have to make a record. And if my court reporter can't hear you, I can't catch everything then either. So it is important when you make your arguments that you speak slowly, that you speak loud enough so everybody in the courtroom can hear you. I think that I'm kind of an informal person, so I don't require people to stand. My court reporter has kind of mentioned to me, like within the last 2 days, that if I would require the young lawyers to stand when they were making their arguments, that A, it would look more professional, and B, he could probably hear them better. So it doesn't ever hurt to be the most professional person in the room. And frankly, I think we'd all agree, come prepared. And you will find that, you think you're prepared, and then comes the, things from one side or the other that you never anticipated. So you just take a breath, decide how you're going to respond, and take the time to do that. So, and I think if you want to be in a courtroom, find employment that gets you there every day, because that makes you comfortable in that world, and it'll take about 2 days, and you'll be fine in that environment. So that would be my 2 cents.
Well, as far as what I would expect from a new lawyer, and I think Judge Trimble has covered it well, but basically I during the years of practice, when I had a new lawyer in the courtroom, I wouldn't say gave them more leeway, but basically, might not, and I was never tried not to be harsh with any lawyer, but definitely wouldn't make any suggestions that I might to an older lawyer. If there was a mistake, if I'm going to make a suggestion, it's going to be afterwards saying, you you maybe could do this a little different when you talk to them personally, and to some extent, especially on the criminal side, my experience was some of the new lawyers you got more out of than you did some of the older ones. You know, they might not cite a case that just says the law says this, and the young lawyer or the new lawyer has done some research and spent a little more time on it than the person that's in there every week. And I think we'll maybe get into it with the next question, but there are certain thoughts I have that I might get into at that point in time relating to some of the things that Judge Tranel referenced, you know, getting to learn about your judges and this type of thing.
You know, I think the other two judges have covered this. I wrote down 4 things on expectations. One is preparation, and both judges referred to that. And, you know your case, know the law, but also be prepared in terms of how you're going to present it. And I'll give you a couple of examples. One would be if you're going to bring documents in or exhibits and you're going to present those to the court, have an extra copy for the court. I mean, that's just a real simple thing, but there's a lot of times you'd be amazed how many times lawyers don't think to do that, and so they're down talking to their witness about this exhibit, and I have no idea what it says. I'm sitting saying, that'd be nice if I knew what that document says, and I don't know. So, you know, have an extra copy for the court. That's just one example in terms of being prepared and being ready. Have your exhibits marked, ready to go. You know, have your witnesses there on time. You know, those sorts of things that are part of preparation, so that the court doesn't have to sit and wait for you. You know, in criminal cases, you know, have your if you have a PSI, have that reviewed with your client so you're ready to go at the time set. If you're doing something with your client, you need to talk to them on a criminal case. You know, if they're going to plead or something like that, have that all ready to go so the court's not sitting waiting for you for 5 or 10 minutes while you're talking to your client saying, okay, here's what the state's offered us. And sometimes I know you can't help that because there are last minute deals made, but try to get your deals made, try to get things done before, if the court's set for 9 o'clock, get it done before 9 o'clock, get it done the night before, because I'll just tell you that one of the frustrating things for me is if I have a full calendar and I'm sitting waiting for somebody and they say, oh, I got to talk to my client, I haven't reviewed the PSI, or you know, whatever. And so, you know, be prepared with those things so you're ready to go at the time set. You know, and in terms of knowing your case, I mean, there are times when I'm doing the research for the lawyers, you know, because, and this is what you're going to run into when you're in practice. You're going to run into that conflict between how much time can I bill to prepare for this and versus really being prepared for the court. And it's a struggle. I mean, it's a struggle when you're in practice. You know, it's a case maybe you don't want to overbill your client, and you're trying to judge all that. But be prepared with at least the basic law, so that if the court says, well, what statute are you referring to? Well, you know, I think there's a statute out there somewhere. I don't know where it is. I mean, you know, just those basic things on preparation. So preparation, honesty. You know, the worst thing that you can do is not being honest with the judge, because the judge will remember that. And I mean, there are lawyers that appear in front of me that I check much more closely at what they present, the arguments they present, because I've had them maybe not be completely honest, or maybe they haven't presented exactly all the facts or things that are pretty significant. And so, you know, if you develop a trust with the judge, it's going to go much better for you than if you are kind of, well, I don't want to tell the judge the whole story. And I understand you want to be an advocate, but you need to be honest in your situation. Collegiality, you know, don't be difficult with the other side. Don't make things difficult. And then the fourth expectation is perspective. Keeping your eye on the big picture. You know, I know when you're preparing the case, it's so easy to get lost in the details of the case, but you got to keep your perspective on what's this case really about. What are we, instead of getting lost in sort of side issues, and that's easy to do when you're an advocate. and it's easy to do, to get lost in some of those areas that, this is really important. Well, does it really matter to the case? How much time do you really need to spend on that? And I would say, I don't know about you two, but I would say probably perspective is the biggest thing I've learned on the bench that I don't think I had an appreciation for when I was practicing, is seeing the big picture. Because you just sometimes miss it when you're advocating and you're kind of focusing on certain things. So just keep in mind the big picture. Those are the 4 things I had.
Judge Trandall mentioned the website to find out judges' preferences. Is there anything you'd like to add to how a new lawyer should find out a judge's preference?
Well, yeah, I can, well, first of all, I think it's not only as far as a young lawyer, but I know when I was an older lawyer, but I was going into some venue where I had no contact with that judge and didn't know him, that you learn about those preferences, and it's very important. Other lawyers, if you end up practicing in South Dakota, you've got classmates in this area or that area, get in touch with anybody you know in that particular venue to discuss the do's and don'ts with about a particular judge. Talking to the court reporter about the little things in the courtroom, because there's nothing nicer as a lawyer not to worry about what you do next and knowing how you do it, and so you can worry about the big picture. For instance, some judges make you ask to approach the witness. Some judges don't. Find out those little things ahead of time. I never cared to have anybody ask me to approach the witness, and sort of it didn't really bother me, but I just take it up time every time I get to ask. But find out those particular things. And also, when you're finding out about the judge, find out how amenable that judge is to talking to you, not in an ex parte situation, but answering some of those questions. I think all 3 of us here were very open to talking to lawyers about just procedural matters, but find out, because there's maybe a handful or less than a handful of judges in the state that don't have that same particular attitude as far as lawyers coming in and talk to them. But I've always felt that if a lawyer comes in and asks a question about procedure or how that lawyer should do, that there's no question, don't feel it's a dumb question, because there's no question that's a dumb question along those lines. Just little things that you might not pick up in law school necessarily that are so procedurally simple. I had a young lawyer trying his first civil case in front of me, and we get the jury picked, or we didn't have the jury picked. We got to the point where we were striking the 3 preempts, and I wasn't paying attention. I said, give the sheet to the plaintiff, and I was talking to the jury at that time, and it was taking quite a while. And finally, my court report returned to me and said, it's taken him a long time. I asked him to approach. Well, he had taken all 3 of his before, switching it back and forth. You take one, give it the other side, they take one. Obviously, but just little things like that. Make sure you know that particular procedure, and if a judge wants you to stand up, find that out ahead of time, and don't be afraid to ask the judge what he or she prefers in the courtroom. But learn the judge, and don't be afraid to ask questions.
perfect lead-in for the student questions. Don't be afraid to ask questions. So now's your opportunity. This is a great environment, a safe place to ask questions of our judges. And if you don't mind just introducing yourself and maybe saying what year you are in law school before you ask your question.
Is everybody third year here, or not necessarily? Some second years?
Judge Jensen, I'm Tyler Manson, by the way, I'm 3L here in the law school. You mentioned that there are some difficult cases and at difficult times as a judge. How did each of you sort of prepare for those situations and deal with the aftermath of some of those difficult situations emotionally?
You know, for me, I guess I have a great ability. I guess I've been blessed with a great ability to forget about my case at the end of the day. I got about a 20-minute drive between courthouse and my home, and you know, I try to just put it all behind me. I mean, you know, sometimes you have to prepare for the next day if you're in the middle of a multi-day trial, but I make the decisions, and it's stressful at the time. You make sometimes some very difficult decisions, but you can't second guess yourself. You can't, say, well, I wonder if I messed that up. I wonder if that's going to get reversed. You basically make your decision and move on. And I'm fortunate in that I seem to be able to go to bed at night and forget about it. And that's not to say that I make every decision right, because I don't. But I think that's the biggest part of it is, you make your decision and move on and let go of it and realize you've done everything you can do and then move on. And I think it's the same way as a lawyer. You make your best argument, and I'll never forget, and this is a little bit veering from your question, but I think it's one of the best pieces of advice I received as a lawyer. I got absolutely destroyed in a case I was defending. And the plaintiff had punitive damages on top of compensatory damages, and much more than what we offered prior to trial. And there was some bad set of facts. I didn't think it was going to be that bad, but it was. And I remember, next day I'm sitting in my office thinking, I don't even want to know if I want to keep practicing law after this. But one of my senior partners came in and he said, he said, you're stuck with the facts and the law. He said, you can't change those. All you can do is you can make your best argument. You can do what you can do with the facts and the law that you have. But you can't change them. And I think that you have to walk in every case with that. And you're going to have, as a lawyer, you're going to have some very difficult cases that you're going to have to advocate for a client for, and it may be a losing position. But you do your best job, and you realize the facts are the facts, the law is the law, and you inherit whatever your client brings into you. And I think that gives you a little bit more peace of mind to keep that perspective.
I'm kind of wired the same way because I call it pulling the plug every day. The day's gone, it's done. The problem that you have with a judge that does that, though, is that if you made an argument in front of me 2 weeks ago, and then you come in and it's round 2, you might have to remind me a little bit about round 1 because I may not, I'm not a visual person. I have to conscientiously make myself remember those kinds of facts. And so I pull the plug every day. I do live in a very small community, and I make sure that I'm engaged in all of the communities that I'm a judge in. So I go to basketball games, I go shopping, I buy groceries. I make myself really a part of that community, so I am anything but anonymous. And my husband moved here from Houston several years ago and landed in winter, and he was used to that anonymity, and in a small community, that was gone. So what happens is you go to court, and it's a nasty custody fight, and you award the children to the dad, and then you're in after court buying groceries and you're in the dairy section and in walks the mom that you just took the children from. I mean, you know, it's just one of those things. You're just courteous. I just try to, you know, I'm trying to be nice to everybody at all times. I just ran into a guy. We drove from Winter this morning, and we stopped in Bone Steel at the convenience store, and one of the guys that's in my courtroom quite often for minor criminal behavior walked in, and he said hello, and I said hello, and, you know, I mean, it's one of the great things about living in a small town, and I can clear a bar in about 20 seconds if I walk into one, and that's kind of fun to watch, you know. But so you just take it a day at a time, and you know, some of the most difficult cases, we all handle stress different ways, but you do have to set up ways so that you balance that out. And I think some of the most difficult cases that I've heard are really termination of parental rights cases. And you get done with about 3 days of what those kids have lived through, and you go home, and it's just, you just feel filthy. And then you think, well, okay, I've survived 3 days of this. These kids have lived their whole life like this. And so it does put that into perspective as well. And actually, some of the cases that are the most difficult are also some of the most interesting. So, I mean, you get kind of an interesting perspective when you get a call at 9 o'clock in the morning that there's been a murder in Martin, and you're going, oh, this is going to be interesting. And it's a terrible situation, but, you know, those are the cases that stay with you for the rest of your life. So.
Well, I can basically just mirror what Steve and Kathleen said. I never really had any emotional problems after I had made the decision. I basically forgot about it. As long as I felt I was doing what I felt was right under the facts and the law, I was happy with that, and I would go on to other things and figure if I was wrong, the Supreme Court would tell me I was wrong, and I had never worried about the Supreme Court near as much when I was a judge as when I was in private practice, because they reversed me, it didn't cost me any money, which wouldn't. And I sort of, in some cases where you didn't make the decision, obviously, where you took it under advisement, you know, there you keep thinking about it, but I always tried to get that behind me as soon as possible. And Steve mentioned driving 20 minutes. I had about 40 minutes, and I remember a few court cases where I left the bench thinking, how in the world can I ever figure this out? But when you sit in the car for 40 minutes, you sort of got to put together in your head by the time you get home. If you drove 2 blocks, you'd forget about it for a couple days. I had, when I first started practicing law, an old deceased lawyer now, Ellsworth Evans, who founded Davenport Evans, told me, he says, Dave, when the case is over, forget about it, think about the next one. And that's a good, I think that's a good motto to follow, even not just as a judge, but in your own practice, because if you lose a case and you sit and second guess yourself, you can critique yourself, so you don't see what you might have done wrong, but get on to the next thing, don't worry about it, because everybody's going to lose some. If they say they don't, they're lying.
My name is Bethany Huta. I am the 3L as well. And kind of going off of Tyler's, how do you balance work and home life?
When I went on the bench, my kids were 2 and 5. And you know, Martin's 102 miles from Winter, and Burke is about 28. So there's a lot of miles. And there's, you know, frankly, some late nights and some weekends that you work. So my only answer is that when you're at work, you're at work. And when you're at home, you're at home. And when you're at a sporting event that your kids are in, that's where you're at. And that's the only way that I could make that work. Now, you know, I also got divorced as a judge and in a small town, and I wouldn't wish that experience on anybody. However, you know, I had my non-negotiables and my negotiables, and I had a really good lawyer who helped me through that process. Because even though I did a lot of family law, I certainly hired a lawyer to get myself through that process. So, you know, the thing is we're all human. We all go through those experiences, and you just make it work every day. And you can make that work. And you can have, I mean, the father of my kids was very involved. We shared parenting. If I had to be out of town or out of state, he had the kids. If he had to be out of town or out of state, I had the kids. It was, we worked through that. So, I mean, we live lives just like everybody else does. And I think that you know, you have activities outside of the office. I don't think any of us are married to our jobs. We all have activities and hobbies and things that we all do, and you have to take time for those things as well. And so that would be my answer.
Well, I guess I'm in a little different situation because by the time I became a judge, my kids were gone and they were out of college, and I think my daughter was already a lawyer by that time. But so I never, actually, I had a much easier time than I did in private practice because I was virtually home every night instead of missing out on things or doing other things. The one thing that, you know, if somebody would call you up and say, you know, can you get away and go hunting tomorrow, and you had some lawyers coming into court, you know, I would never cancel anything for that. If I was in private practice and had some appointments, I might call them up and reschedule it. But on the other side of the coin, to some extent, if you wanted to take a vacation, I found it a little easier to do that when you were a judge, as long as you planned it way ahead of time, because if a lawyer called you today and wanted a date in May, they don't care if it's the second week or the third week if you're going to be gone one of those particular weeks and taking a vacation. And when you're in private practice, some judge can screw up your vacation by saying you have to be in court, which you don't have that problem when you're a judge.
I would never do that. So, yeah.
No, and
yeah.
You know, virtually no lawyer or no judges on the state level in South Dakota would do that. I can't say anything definite about the higher level.
Yeah, I had 3 kids at home when I started on the bench, and you know, I think I would agree with Kathleen and Dave's comments. I think, you know, having a good balanced life. You know, I like spending time with judges and lawyers. I like talking to them, going to lunch with them. But I have a lot of friends that are non-lawyers and have some friends that aren't lawyers, because you got to get out of this legal world from time to time and not just get stuck in that world. The other thing, being a judge and hearing a lot of difficult cases, is you'll find the same thing as an attorney. It makes you appreciate your spouse and your kids a lot more when you come home. It's kind of like watching a soap opera, and you say, wow, my life's not nearly as dysfunctional as what I thought it was.
Yeah. Yeah, you do. You go home and thank God for your normal life, because crazy things happen in other people's households, and especially if you do family law, you will hear things you never knew existed in this world. And so, yeah.
My name is Chris Summers. I'm a 3L. Besides lack of preparation, what would you say is your biggest pet peeve in how a lawyer conducts themselves in court?
I've got 2. I don't know if I could narrow it down, but I'd say my two would be, one is wasting time. You know, I know you want to make your points, and I know sometimes as a lawyer you don't know if the judge gets it or not. I mean, I understand that, but to continue to repeat, you know, for instance, in the divorce case, bringing, you know, 5 or 6 witnesses in who are going to say the exact same thing. Oh, I live next door, and mom's a great parent. You know, I live 3 blocks away, and I see her at Card Club every day. She's a great mom. You know, to have 5 or 6 people come in and say the exact same thing is a waste of everybody's time. And so, just some of those things. Think about, okay, what do I really need to present? What do I really need to convince the judge on this case, rather than, you know, repeating the same questions or bringing in a lot of repetitive evidence. That's number one. And number two is poor cross-examination. There's a lot of lawyers and even experienced lawyers that don't know how to cross-examine witnesses, and I'll sometimes hear, I've heard the direct examination, and cross-examination sounds exactly like direct examination, and that's not what cross-examination is about. And you know, I'm sure some of you have taken trial techniques class, and that's something to really work on when you get into practice is honing that cross-examination. It doesn't need to be lengthy. You don't need to ask an hour and a half worth of questions on cross-examination. I don't know if any of you either you know Judge Bennett from Sioux City, federal judge in Sioux City. Very smart now. He's easy to practice in front of, but he told me once, he said the best cross-examination I ever heard was a case where there was direct for an hour, and he said the lawyer on cross asked 5 questions, and he said it was unbelievable. He said absolutely destroyed. Now you're not going to have that opportunity every single time, but you know, be thinking about, you know, how can I attack credibility? What can I do to discredit what this witness just said, or you know, rather than going back and regurgitating everything that was said on direct. So those are my 2 pet peeves.
Well, I don't have anything to add, because if I had to list 2 pet peeves, it would have been exactly the same 2 pet peeves. The cross-examination, especially in court trials, but it can go into jury trials. In divorce cases, you probably end up, as a judge, hearing more divorce cases in court trials than other type, but you know, it's just a reiteration, and I think Judge Jensen mentioned earlier the perspective. The lawyers sort of forget the perspective, you know, and calling, well, not only calling the witnesses to testify that mom's a good mom or dad's a good dad, but then the other side getting up and asking a bunch of questions in cross-examination, which virtually the best way to handle a witness like that is say no questions, and because you're not going to get any place, and you're certainly not going to, but the judge is going to be looking at the total bigger picture, and is going to be much more interested if there's a home study testimony than what some neighbor might say. You know, I always said that if you why call the grandmother to say their child is a good parent? It's when you call the grandmother of the other parent that says that parent's a good parent that it's news.
The only thing that I will add is email communications. I will schedule by emails. I'm not going to hear argument by email. I don't want, and sometimes, and so if you're new to me, you'll send me one like that, and I'll say, file your motion. You're not making a record. It doesn't go into the clerk's file. There's no court reporter there, so you're not making your record. And I will not do those by email. So I've warned once. I just start deleting after that. And I really don't appreciate getting in the middle of lawyers' arguments by email. Do not copy me, anyway, for those, because the substantive work must be done in a courtroom or by briefs. And the one thing that I see young lawyers do is they're not filing, because we have Odyssey, I don't know why, but, so they're not always filing briefs, which they used to not, but now we can, and I prefer that briefs be filed so the Supreme Court knows what arguments were made to the court. But you've got to file documents with the clerk's office to make a record, so that if you do not agree with the decision of a judge, you can appeal it. If you've not put anything into the record to make that happen, you've not preserved your issues for the Supreme Court. But the emailing of the court on issues like that, on substantive law, I'm not going to make decisions by email. And I give everybody, like I said, one warning, and then I'll just ignore you. So, and you're going to find we all have different ways of handling that. Obviously, some do, because I keep getting them. So there must be judges out there that approach works. But I want the arguments made in the courtroom when everybody's present, when the parties are there, because I think that is the fairest way to ensure due process. So,
one other thing that occurred to me is that, and not all judges are that way, but if you're trying a case in front of a judge, usually in a court trial, but it can happen in a jury trial, and that the other side's examining and that judge is looking at you all of a sudden, generally he or she is telling you you should be making an objection.
Yeah.
The other good hint, taking a body language hint from a judge, they're taking notes in the court trial and they put their pen down and you're examining a witness. That might mean that they're done, they've heard everything they want to hear from that witness.
Or move on to the next topic.
Yeah.
The horse is dead, move on.
And, since we got into that, I spoke at a couple seminars, which I didn't realize as good when I was an attorney as I did after I was a judge, and that is that try to, when you're calling a case, both in a jury trial and a court trial, is get the meat of your testimony out right away, rather than going through a bunch of background for 10, 15 minutes, because regardless of how bored a judge might be or a jury is, whenever you call a new witness, that attention factor comes back big time. So if you get the key stuff in right away, you know what's they're going to hear it.
Each of you, my name is Anthony Sutherland with 3L. Each of you kind of mentioned your time as an attorney before you were a judge, and managed or talked about how you kind of manage your time, that feeling of I can only spend so much time on this, whether it's for a financial reason or I want to spend time with my family. How did you actually go about balancing that and kind of making that determination in your respective practices?
Well, one of the big things I think is case selection is important when you're an attorney, and I think particularly as a young lawyer, you're a little bit more idealistic and you want to help everybody out. Everybody walks in, at least I was that way. Everybody walked into my office, I was gonna save them, and you need to have a little bit of cynicism and a little bit of stepping back and saying, okay, what does the law say? What's a jury going to think about this? What's the judge going to think about this? And as a lawyer, I sometimes got involved in cases that I get halfway through the case, particularly as a young lawyer, and I'm saying, why did I ever get involved in this case? And that's just an example of, had I not taken that case, I would have had more time either to work on other cases or to personal time. And so I think, aside from delegating work and learning how to delegate your work, I think case selection is extremely important. Also in terms of just keeping your sanity as a lawyer and not, the old saying, working smarter rather than harder.
That's a very good point, and I think it's difficult when you are a young attorney to say no. Somebody comes in your office, they're in a crisis moment, and you do want to help. The best advice that I got in that world was Rick Johnson, who was a trial lawyer in Gregory, and he said, you know, Kathleen, when people are in crisis, you need to get the retainer up front. Because if you're going to take clients and not get paid, you should do that intentionally. I mean, if somebody comes in and they absolutely cannot afford a lawyer and you've decided this is the person that you're going to help this month with that problem, just know you're not going to get paid and make that straight up front. But when somebody is in crisis, they will find the money because, you know, we have to buy diapers and formula and, you know, make the house payment just like everybody else does. So get the payment up front because once you've resolved their crisis, it's done for them. And then trying to get paid at that point becomes very difficult. And so, you know, from that perspective, I think that that's probably the best advice I got when I was running my own business, which it is also a business.
I agree with everything that's said, and since I retired, I've been doing some mediation, and some of them are in divorce cases, and I can't believe how many I've seen that I know they can't pay for their attorneys, and I just think, you know, and they obviously come to mediation to avoid a 3-day trial, one way or the other, but you know, so you've got to be very careful, and I sort of feel for the people that need a divorce that have got $60,000 worth of credit card debt and are making $40,000 a year.
And they added $15,000 for their lawyer.
Right. Yeah. But you know, you've got to be very careful on that because I think there's a lot of lawyers that you know, have really got down on the profession because their accounts receivables are so terribly significant.
And both have mentioned divorce cases. I think those are the worst cases in terms of that retainer up front. Those are the most important cases to do it because, I mean, the reality of it is, you know, if it involves your child, there probably isn't much you aren't willing to do to you know, try to do the best thing you think you can for your child. And it's usually divorce cases, the lawyers that don't get retainers up front that end up having lawyers' accounts receivable.
And that makes me think about one other thing, and I notice it some in the criminal world, and I notice it some in the divorce family law world, probably others, but you know, there are times where your clients are not going to have reasonable expectations. And as my court reporter says, you have to be able to take them by their lapels and explain life. They have to understand that the situation that they put themselves in has consequences. And, you know, as Judge Jensen said earlier, you've got the facts and you've got the law. We're not magicians. But sometimes they just have to understand that that's what the law requires. And if you think you want, you know, I have a divorce where the woman embezzled from a local business hundreds of thousands of dollars. And he wants to keep all of his property. Well, they've been married 20-some years. The property gets divided. I know he feels wrong that she's embarrassed him and put him in a terrible place, but property still has to be divided. So, you know, and fault is not something that you can consider in property division. And so it's going to get divided, and she's not going to walk out with nothing. She's going to get a car, she's going to get some furniture, she's going to get whatever she's going to get, and he may have to pay her some cash, and he's going to feel really bad about that. But you have to just say, look, this is what the law provides. If you've been married for this long, You're not walking out with everything and leaving the other one destitute. It's not going to happen. Or in a criminal case, and that's part of preparing your client, especially in cases involving domestic abuse. They'll come in and they'll plead to the assault, whether it's aggravated or simple. Well, I didn't really hit her. Well, I didn't really do that. Well, then don't plead guilty. I can't take your plea. So you have to prepare your client so that they understand what will be expected of them when they come into the courtroom as well. That is really off from your question, but I think it's important for especially young lawyers to have that ability and that confidence to say, look, this is what the law says, this is what the judge is going to require, and if you don't want to take the plea deal, we'll go to trial, but then you're looking at this instead of this, but you're going to have to admit that what you did was wrong, and that you did the acts that caused, that put your girlfriend or whatever in the hospital. So, and a lot of times, those are really the most fun factual bases to take because it's just a total, I didn't really do it.
Or it's, I really don't remember what happened.
Yeah, I didn't, yeah.
It's all just a
Blur.
blur.
Yeah.
The other thing going way, Kathleen made me think of it, but going back to knowing your judges, if you're representing somebody in a criminal case and they plead guilty to a felony, there's no question they're going to ask you, what do you think I'm going to get? And if you're not in your own community and you're out of the particular area, that's another place where you should talk to the attorneys that you know in that particular area just to get a little feel on sentencing. You're not going to be able to tell your client what they're going to get, but you can say, this is what I learned, this is the best I can give you, and so you don't wander into, there's not many left. There was one at one time that was pretty much going to give the maximum on every particular sentence, and there were a few lawyers that walked up there thinking it's a probation case, and all of a sudden they did 5 years in ban.
So the best advice is to tell them to bring their toothbrush. And if you get anything less than that, it's because I'm a fabulous lawyer. I mean, because here's the deal. There may be aggravating factors in any sentence, and there may be some jail time. Or if you come into, say, my courtroom on a second offense DUI, you're going to get 5 years or 5 days. Doesn't matter. And other judges do other things. That's my deal. You got to have some time in jail, because if you get a third, you're looking at prison. So I want you to understand that when you're coming in. I'm also a treatment person. I want the evaluations before I sentence. I want to know what the treatment opportunities are for somebody if they have addiction issues, and that's going to be required as a part of the sentence. There are other judges that don't really go down that road, but you need to know that before you walk in, so that you know, if I plead today, can I get sentenced today? Well, not if you don't have an eval, because I want to read it before sentencing. And other judges will just order it as a part of their sentence. So that's another area where you really need to ask some questions and know what you're getting into and what your clients are getting into.
My name is Kyle Chase. I'm also at 3L. So my question is, aside from hearing cases, what are some of the behind the scenes, if you will, other duties and tasks that you actually do as a judge?
Besides speaking to law school class.
Yeah.
That's one of them, I guess.
Yeah.
Well, I guess both Steve is now, and we're both presiding judges, which there you're doing some administrative work. You're talking to your court administrator about not necessarily doing the interviewing, but hirings and firings in clerk's offices, and sometimes you end up spending time doing, when you're selecting a chief court service officer, or if you're hiring a new administrator, spending time going through resumes. You also spend some time in in our circuit, at least the presiding judge did it, hiring the law clerks and coming down here and interviewing and going through the application process. And, you know, just, and obviously you try to keep up and read all the Thursday morning when the Supreme Court decisions come out. You try, as soon as you have a chance, go through those and just organize things so that if you got any cases that you know are pending where that might have some applicability, make sure you've got a reference in it, and those are just some of the things.
We're in the process right now of going through the warrant list. We've got some counties that have warrants back to 1977, which is ridiculous because obviously they're not going to pay, or they're dead, or they're from out of state or whatever, so we're cleaning some of those things up. Just signing orders and going through mail takes some time. We now do some of that on the computer through our Odyssey program. I do a few weddings every year, which are great fun. I'm an adopted kid, so every adoption I get to have is a fun opportunity in a courtroom, so we do that. We do try to talk to Rotary and the city councils about different programs that we're, implementing. We have Hope Probation, which is a 24/7 program for drug addicts that we now just we'll celebrate our first anniversary at the end of the month. But that takes a lot of making sure that, law enforcement is doing all of our UAs for nothing. I can't, the only thing I can do is provide free UA cups. And so some of that, politicking to get the things that we want for the programs for our communities, we certainly spend time doing that. And so.
Yeah, I guess the only additional things I can think of, are case preparation. Particularly for criminal cases and juvenile cases, a lot of times we'll get reports and things that, I had was that this Monday? No, Monday we didn't have court. Must have been last Monday. I hadn't had court for 2 weeks in Elk Point, so I had a long criminal day, and I spent probably 6-7 hours over the weekend just going through reports and familiarizing myself with cases. Like Kathleen said earlier, you see these cases, but we don't spend as much time with them as the lawyers do. So you have to kind of go back and familiarize yourself with the case and get up to speed on it. We spend a lot of time in training. I'd say probably 5 to 10 days a year, probably in judicial training, which I would have to say we're very fortunate in that we have a very good training program in the state for judges, laws, changes, and case decisions, things like that come up. I think we're really fortunate to be able to be up to speed on those things as a result of training. And so I don't know. I guess it takes all our time anyway.
Thank you.
My name is Deb Morris. I'm also a 3L. Would you please comment on civility in the courtroom as well as in pleadings? If there's something particularly bothersome or as well refreshing to you that you're finding, whether it's in new attorneys or long-time practicing attorneys?
Well, I can't stress how important civility is. And it's maybe more important in a state like South Dakota, because if there is a uncivil lawyer out there, that reputation can spread across the whole state. If you're in New York City and you're uncivil, you probably fit in pretty good, first of all. But no, it's just probably a handful that know about it. I really, except for a couple, three that from my days in private practice that I know have bad reputations in the state, whose names I won't mention. I really, in the 10 years on the bench, didn't have any civility problems. But when I was practicing, and I might have been involved when I first started in some of it, I think there's a tendency to be a little too adversarial in some of the discovery processes, and just making objections to discovery that you shouldn't make, forcing motions to compel, and that type of thing that you don't see when they get up. And I think the most times that you will run into lawyers in this state, fortunately, because I think we've got a great bar, is when you've got some out-of-state lawyers come in. I was involved with some lengthy litigation with mostly out-of-state lawyers. I mean, it was screaming matches at depositions, and here in South Dakota, basically everybody sits around and gets along good during the deposition.
I agree, and when you practice in a small state or a small community, you're going to see everybody that you're practicing against on every court day. So to not be civil will have consequences. I mean, you just have to get along with everybody because you're going to see them all the next time. It's not like somebody's going to drop in, and we've had those instances where we've had somebody that has not done a good job or has been very unprofessional. But, you know, Judge Jensen talks about our trainings. How many circuit judges are there? 52? We all talk to each other. So if we have a lawyer that's not honest with us, or who is, you know, throwing grenades in a courtroom, it's not going to take very long for everybody to know that that's the demeanor of that attorney. So now sometimes things can get heated because that's the nature of some of the cases. But you just have to make sure that you don't take on the persona of your client, who might be very agitated and upset, and it doesn't help the cause to do that. And so I think because we are a small state, because we all see each other often, I just don't see problems. I rarely see problems on that front. And if an attorney has been inappropriate, which has happened, an apology soon follows, because you can get caught up in the heat of the moment, and if it does happen, acknowledge that you did something that you shouldn't have, and just apologize to everybody involved and move forward.
Yeah, I don't know that I have anything else to add. I think being Teflon is the best thing that you can do. If somebody wants to, you know, the old saying, sticks and stones may break my bones, but words will never hurt me. I mean, there's a lot of truth to that in the legal practice, and I think that, you know, not responding in kind to somebody that's difficult, it never gets you anywhere to respond. It's kind of that same thing of perspective, you know, maintaining perspective in your case. You know, getting into it with the other lawyer isn't going to probably help your client or advance your case.
And the other thing, the one other thing is sometimes clients, and you sort of have to deal with this, are upset because you're being nice to the other attorney or not. And I remember one mediation I've had since I've been doing mediation where one of the parties wouldn't even shake the hand of the other attorney because it was an enemy. So you've got to, I guess, get used to that in some cases.
Noel Weiss, I'm a 3L. I guess my question is just about how technology has maybe changed how you guys do your job, or social media, how you see it maybe interfering or coming into play with what you guys do.
It has been a huge change since I started practicing law. The court system finally is going paperless. which is great. Social media makes things difficult. I do have a Facebook page. Not everybody does. I have high school friends and some of my colleagues that I am friends with. But every week I get requests by law enforcement officers, which I cannot accept. I do not accept friendship with lawyers that practice in front of me. I've had a couple of people in criminal cases who are charged with criminal cases try to friend me on Facebook. I find that humorous. So, you know, there has to be some boundaries there, and you just have to look at it from the perspective, how would you like the other side to see that you're friends with a cop in a criminal case when they're in your courtroom every day? I mean, we all have professional relationships with everybody that we work with, but there has to be those boundaries. And then I think also judges have to be very careful about what they post. And I think lawyers do too. The listserv, for example, at USD, I remember several years ago, there were some very derogative remarks about judges in a particular circuit. Well, we're all on it, so if you're going to call us names, that's probably not the right place to do that, and it's inappropriate in that world to use it in that way if you're frustrated about something. And then make sure, you know, the one thing I wish lawyers would do is they push reply, not reply all. And then I have to go in and add everybody, or email them back and say, please add everybody to the mix. And then if it's 2 lawyers, I'm happy to do it. If it's, you know, many, then it becomes a little more time consuming. But so it does change our world. The courtrooms are not, where I am, are not really equipped for technology. And so if you're going to have a trial there, I think you should come early and see if the equipment works, if you know how to work it. We had a trial recently. We couldn't get the Elmo, which was so you could see the pictures on the wall thing. They couldn't get it to work. And so their whole strategy then, if they'd just come over the Friday before and spent some time with it, I think it would have worked much better. So find out what technology the courtrooms have if you need to bring your own, and then make sure that it's working before the trial starts.
I think it's, I think that one of the biggest struggles with technology is that struggle between the formality of the rules and the informality of technology. I mean, I was born a generation late to understand all the technology, but what I see is the opportunity to be very informal in your interaction, communication with judges and with attorneys, and you know, of course, the downside of that is one is being careful of ex parte contacts with the court. Kathleen alluded to that with emailing. Don't just send an email to the judge. Make sure everybody involved in the case is copied in on it. The other part of that is responding without thinking. You know, it used to be you'd sit down and dictate a letter, and the letter would come back, and then you'd review it, and you'd say, oh yeah, this, you know, I should take this out or delete this or whatever. Or I'm cooled off now 2 hours later, so I'm not going to put this sentence in. We don't have that opportunity anymore. Now I get an email from somebody and I want to shoot right back and respond to them. And I think that's changed the practice. And in a lot of ways, the law is very formal. We've got rules of practice, and there's reasons for that. You know, it's changed. We've changed the way we serve documents, the way we file documents. Those things have changed from where they were, but we at the same time, there's some reason for the formality we have, and keeping that balance between the formality and the informality of technology is going to be an ongoing struggle, I think.
And then in the divorce world, your clients will all have Facebook pages, and they will be humorous. And I can't tell you how many cases where that's the evidence. Inappropriate behavior with the children, or, you know, or the mistress shows up, or whatever happens there.
Or text messages.
Oh, text, yeah.
Really? You texted that?
Yeah,
Why,
yeah.
Why did you say that?
Yeah. So really, to explain to your clients that, you know, they really can't live that way, in the middle of a lawsuit is important. And keeping a paper trail when you're talking about visitation and what's going to work is a good thing. There are times when that's probably more appropriate than screaming over the telephone, but at the same time, there is a balance there, and so everything that's said, it's either going to be on the front page of the Argus Leader or it's going to be in front of a judge, and so you really have to use that as your standard.
I don't disagree with anything that's said. The one other area that I've seen technology is if you end up in any business litigation, and it doesn't equate so much as being a judge, but more as an attorney, extensive business litigation, you've got those, the discovery just gets voluminous now as far as emails and well, you can see how long it's taken, even though that's astronomical, of just even getting the emails from Hillary Clinton out in the public domain. But I haven't been involved in any, but I've talked to lawyers that I've got stacks of emails this high on discovery and business litigation cases, and I imagine not so much in South Dakota, but other states where you've got some of these patent litigations and theft of trade secrets that
I have one of those right now, and the discovery is difficult because they want every email, and then how much is too much, and then the time frame to produce that information, and it's a difficult process to manage even from the bench, let alone lawyers through discovery.
I think our time's about up. We really appreciate all the valuable information that you've shared. If you have any parting words of wisdom that you were dying to share that we didn't get to.
You guys are at a great place, so keep an open mind. You don't know what opportunities. I don't know that any of us sitting here now ever thought when we were sitting there that we would be judges. And so those opportunities, whatever they are, right for you. So just keep an open mind as they come to you, and then make those decisions as you go through this. But this is a wonderful way to live. The practice of law gives many opportunities. So just keep an open mind.
Well, and I think the other thing is, from my experience in South Dakota, not just as a judge, but as a lawyer, especially maybe not my first 5 or 6 years before they got in the unified judicial system, but the judges, there's always exceptions, but are great to deal with in this state, and I've tried some cases out of state, and so don't be afraid of the judges. They're all out there to, they're not going to come down and make you terrified or jump on you from the bench, by and large, and that certainly occurs in some of the other states or some of the federal judges I've dealt with that were brought into South Dakota. So don't be afraid of the judges. You've got to be respectful to them, but don't be afraid of them.
After an hour and a half, I know I'm ready for a break usually.
Yeah. Well, we certainly appreciate the time getting here and participating with us today.
Judge Jones said one thing.